Good morning. A fantastic judgment in favor of the authorities and the advocate who assisted financier who financed to purchase the vehicle could not get his vehicle returned to take possession as per hypothecation agreement because the vehicle was confiscated by the NDPS authorities, Drug Disposal Committee, constituted under Section 5 of the NDPS Act. The case was very simple. The financier, when lend loan, hypothecation, Toyota car, but it subsequently it involved in NDPS offence. Therefore, the NDPS authority seized the vehicle and disposal committee e-court action was conducted and it was sold to somebody else. In between, the advocate who was engaged by the finance committee and these finance people did not respect advocates properly and also did not pay fees properly and always run after and nagging the practice of the advocate. Therefore, normally the financiers are not properly assisted by advocates, except a few relative advocates or firm advocates. Here they see the advocate appearing for hypothecated finance company to invoke arbitration proceedings and filed an application section 9 to possess the vehicle by appointing advocate commissioner. The advocate commissioner took the possession and handed it over to finance company. But the government has filed an application before the district court arbitration proceedings and claimed that since the property was seized under NDPS Central Government Act and the order directing to repossess the vehicle must be varied and possession should be given to authority. The district court allowed his application and the vehicle was allowed to be repossessed to the authorities as well as the person who purchased the vehicle, who purchased the vehicle by e-court action. The Section 51(4) of the Motor Vehicle Act says, without the consent of the financier, hypothecated agreement, the name of the owner, the hypothecation should not be deleted from the registry of the motor vehicles. And there is one more act, 67H of the Akbari Act, 1077, which was prevailing in Trivangur's king ruling. But all these things have been negativated. It is very clear that the hypothecation comes to an end when confiscation, statutory confiscation was there. He can very well file other proceedings to recover money from the person if any due is there. The one more thing is that the judgment AR 2025 Kerala 136, AR 2025 Kerala 136, Hegde Finance Limited Kochi versus Vipin Kumar and another. Then they said they ought to have challenged the confiscation proceedings by stating that I am the owner and without my intention or consult or knowledge the vehicle was misused. But I don't think there will be a scope because the vehicle was under the custody of the person who paid some amount. So you must know, I would like to share some particulars about this vehicle transaction. Number one, you can very well purchase the vehicle by a hire purchase agreement. So the hire purchase Financier will be the owner of the vehicle and you will be hirer. Thereafter, that was one of the transaction. If you did not pay 1/3 of the EMI, the vehicle is liable to be confiscated without the order of the court. If it is, if you have paid more than 1/3 EMI, then they have to approach the court, that is arbitration proceedings, etc. Next question arises financial agreement. After purchasing the vehicle by cash, you may enter into financial agreement with the financier, pledging, hypothecating your vehicle. That was then thereafter binding contract, means handing over the RC book, just like immovable property pledge. These all are the transactions. Okay, best wishes.